The appeal Perry against Raleys Solicitors.
Please the court. Lady, my lords, in this case I appear on behalf of the appellant with my learned friend Mr. Quinney, and Mr. Watt Pringle is Mr. Greenbourne on behalf of the respondents. The court, I hope, is fully aware of the facts. I don't propose to recite them. This is sadly one of those now rather many cases that has arisen out of the miners' compensation scheme, which came into existence following judgment given by the late Sir Michael Turner at the end of the 1990s. And many thousands of miners obtained compensation for, so far as we are concerned, what I will describe as vibration white finger, although more correctly the latter word is HAVS.
Yes, I knew it as vibration white finger as well.
Thank you, my lady. And that's how I'm going to refer to it today to demonstrate my antiquity. My lady.
And mine.
This is a relatively short and precise point. Essentially, there are two issues before the court today. The first can be encapsulated by the question, where is the dividing line between the issue of causation and the issue of quantification of damage? Because we will submit that the authority of Allied Maples and Simmons, with which everybody is familiar, emphasizes that dividing line, and we submit that the trial judge rightly identified the crucial question as one of causation to be determined by reference to limb 2 of what we've described as the Allied Maples test. And the second question, a question with which sadly this court has become familiar in recent years, is the extent of the Court of Appeal, or indeed any appellate court's entitlement to interfere with trial judges' findings of fact. Those are, at the heart of it, the two issues in the case. I propose to deal with them in that order.
Yes. I should mention at the outset that there is, of course, another case relating to this same scheme, raising a different point. But there are extensive quotations, especially in the respondent's case, from the Court of Appeal decision in that case. And so I feel sure that everybody is aware that permission to appeal has been granted in that case. And so possibly whatever was said in the Court of Appeal may or may not be correct.
Quite. My lady, and I'm glad your lady raises it because I was going to raise it. We did bring it to the attention of the court just to make sure that there was no question of falling between stools. All I would say about that case, which is Edwards, is that if this case addresses the dividing line from the causation side, Edwards was a case to do with quantification and loss, and so might, to some extent, address the dividing line from the other side of the divide. I think perhaps that encapsulates the distinction in the broader sense between the two cases. One was fought and determined as a no causation case. The other was specifically fought as a no loss case. My lady, with those introductory words, I propose to move straight on to what we submit is the correct approach to causation. And we take this up in our written case at paragraph 12 on page 62. And our essential submission is found in paragraph 13. That is to say that it was effectively common ground, we'd submit before the trial judge, and rightly so, that it fell to Mr. Perry, the claimant, to prove that if properly advised, he would have made a claim for compensation under the services agreement to which he was entitled, And accordingly, if the trial judge, Judge Safman, came to the conclusion, as he unequivocally did, that Mr. Perry could not have advanced a genuine claim, then there is no causation of loss by any fault on the part of these defendants. That was at the heart, we submit, of the trial judge's determination. Now, we've set out in the agreed statement of facts quite a lot of detail of the compensation scheme and how it operated. I don't propose, unless the court requires me to do so, to go into the detail of that. It's now well set out in a number of the authorities. Likewise, in the agreed statement of fact, there is a slight measure of disagreement because I took it upon myself to put in a little detail about the science of vibration white finger. It's in paragraph 3, but I should re-emphasize that my learned friends don't formally agree the second half of that sentence, but because of that paragraph, that's paragraph 3 at page 43 of the bundle.
Sorry, which paragraph is this?
Paragraph 3, my lady.
Paragraph 3.
Halfway down that paragraph, a sentence starts, the process operates as follows. Mm-hmm. That isn't formally agreed. We haven't gone into the extent to which it's contentious. It is a very brief summary of how the science works, because...
Does that matter?
My experience, with your lady's permission, of the highest courts is that I've always been surprised by somebody asking me during the course of the day, well, how does it operate? And I thought on this occasion, I try and get ahead of the game. It doesn't matter if you're not interested. I go back to the written case at paragraph 13. That is, we submit, the question on causation which fell to be determined by the court. And in our submission, in the Court of Appeal, the leading judgment of Lady Justice Gloucester fell into error in conflating limbs 2 and 3 of the relevant reasoning in the Allied Maples decision.
But would you say that paragraph 19 of her judgment was entirely correct? In other words, on behalf of the claimant, it was accepted that in order to succeed, the claimant had to prove that, if properly advised, he would have made a genuine claim for services.
My lady, yes.
And he accepted that it would be contrary to public policy for a claimant to recover against his former solicitors for loss of a chance of being compensated for inability to carry out tasks if the notional claim for services would have been based on a dishonest assertion that he was impaired in his ability.
My lady, yes. And that was really...
That's basically your point, isn't it?
It is, and it was really common ground between the parties. My learned friend seeks to resile from that for the purposes of today's hearing.
Of course, you weren't there, I think, at the hearing in the Court of Appeal.
My learned friend, Mr. Watt Pringle, first appeared in the Court of Appeal, and I first appear here.
Yes, quite. Did Mr. Watt Pringle, are you told by Mr. Quiney that Mr. Watt Pringle made clear that the concession made in the skeleton argument was withdrawn?
My lord, it wasn't withdrawn in the Court of Appeal.
It wasn't?
No, it's only withdrawn in the respondent's case for this court.
I see.
So in the Court of Appeal, the skeleton argument effectively made this concession.
Yes, I know it did.
And that remained, as I understand it, the common stance of both parties throughout the Court of Appeal hearing.
In the oral submissions?
In the oral submissions.
Very well.
So, Lady Justice Gloucester, in our submission, recites the appropriate approach, which is common ground between the parties, but in our submission then fails to apply that approach correctly to her review of the judgment of Judge Safman. And as we say in the written case, the Court of Appeal's disposal of the trial judge's judgment might lead a reader who had not read Judge Saffman's judgment to a tentative view that the original judgment was a document of some brevity and superficiality, whereas in fact at the end of a relatively short hearing, and you've seen the transcript, it was actually a full and detailed analysis of what he had heard and his conclusions based upon his assessment of the totality of that evidence, including, clearly, because he recites it as such, the medical evidence that was before him. So we submit that Lady Justice Gloucester approached the issue on the wrong basis, despite the agreement of the parties. She recites, and perhaps I can turn immediately to her judgment, which starts at page 117. She sets out the brief history. I needn't take you to that. Although it is fair to say, and I think it does underpin the judgment, the Court of Appeal were highly critical of the stance which my insurer clients had taken. And that does come through from the beginning to the very end. Paragraph 12 is, I think, the first slightly pejorative phrase. Raleys put forward a raft of defences to resist Mr. Perry's claim. The nature of the adversarial approach is that insurers will take defences they consider to be appropriate. Fortunately, in this case, liability, negligence was conceded in the immediate run-up to trial, but the Court of Appeal nevertheless was highly critical that it had gone on for that long. I can't say any more about that, but it does underpin quite a lot of what is said. We then go on to the discussion and determination, which starts at paragraph 22 on page 130. And there, Lady Justice Gloucester, and I take you to this because it's relevant to one of the comments she makes later about the trial judge failing to take into account the medical evidence. In fact, she recites here accurately that the crucial factual finding by the judge. So he accepts that Mr. Perry does, present tense, and did suffer at the time of his examination by Professor Kester from vibration white finger at 3SN bilaterally, as well as suffering of a vascular deficit. He was not inclined to go behind Professor Kester's findings, that Mr. Perry had a superneural deficit of 3SN and a vascular deficiency of 3V. That's because there was a disparity slightly between the two doctors on the vascular deficiency, and that accordingly it followed that the claimant clearly did suffer from VWF to a high degree. But it didn't by any means follow that Mr. Perry couldn't perform the service tasks without assistance. And the trial judge then came to the conclusion that Mr. Perry had not established that in reality any loss of function manifested itself in an inability to carry out the tasks. He regarded the question of one of credibility and came to the conclusion, notwithstanding his finding that Mr. Perry clearly did suffer from VWF to a high degree, that he was not satisfied that Mr. Perry had persuaded him that he actually suffered sufficient disability that he could honestly say, I cannot carry out these services. And then he went on to the conclusion. She went on to the conclusion.
Is that the test, that he cannot carry them out at all, or is it simply that he cannot carry them out without assistance?
My lord, the test is that he cannot carry them out without assistance. Yes. And that was, again, common ground between the parties at trial. This was a highly experienced judge. He has heard a number of cases regarding this scheme. He and Judge Gosnell, I think, are the two judges in Leeds who have had the misfortune.
Well, they're the two judges in the two cases that we
and many others. and the assertion that he in some way was misunderstanding the scheme is hinted at by Lady Justice Gloucester, but in our submission it is not something which can be made good when one reads the judgment as a whole.
It's not entirely black and white, is it, Mr. Pools, as to the ability to carry out tasks? You may be able to carry out some, but not others.
Yes.
So there may be gradations of...
There may be, and there are the 5 different heads of services, and it is commonplace that some, and we see it in some of the reported cases, that some claimants say, well, I never did wash my car. And if the claimant never did wash his car before the VWF started, there can be no services claim on the basis that if I wanted to wash my car now, I couldn't. It has to have, as it were, been a change of regime so far as the claimant is concerned. So those of us in the room who have never undertaken home decorating would, if we suffered VWF under the scheme, would not be able to make a claim. Those of us who are ambitious with the paintbrush, who subsequently required some assistance in home decorating, could make a claim under the scheme. So, Lady Justice Gloucester goes on at paragraph 23. However, as I've said, he went on to hold that if, contrary to his conclusions, and on the assumption, as he put it, that Mr. Perry would have met the factual matrix, i.e. could have made an honest claim, then accepting in this respect the evidence of Mr. Tennant, any comorbidity problems arising in relation to Mr. Perry's back problems should only be reduce the loss of the chance by 20%. In fact, the judge expressed himself slightly differently, as the court will have seen. What the judge actually said was, the parties will know what, if any, comorbidity reduction should take place. And from that net figure, there is a loss of a chance of 20% were the matter to have proceeded, because the investigating authority might have queried some or all of the claim. But in the event, it just didn't matter very much. What the parties effectively took was a 20% deduction. But I raise it simply because Lady Justice Gloucester is slightly misreading what the judge actually says at the end of his judgment.
It's a 20% reduction on an already reduced figure to take account of comorbidity.
If there is a reduction for comorbidity, as it happens, I think the parties simply agreed 20% across the board. But I raise it because there is a mismatch between what Lady Justice Gloucester says and what Judge Safman says, which you will have seen. She then goes on to deal with the circumstances in which the appellate court can interfere with factual findings. I'll come back to that, if I may, later on. But it's helpful, I think, to go straight to paragraph 26, because at the end of that passage of analysis of the authorities, Lady Justice Gloucester sets out why the court felt that it was appropriate to interfere with the factual findings of the judge. And she sets out 4 reasons in summary, which she then expands upon. Firstly, the judge made a material error of law in his approach to the determination of the causation question as to whether Mr. Perry would have made a claim. In our submission, he didn't. Secondly, he wrongly assumed that the burden of proof was on Mr. Perry. In our submission, in respect of the issue of causation, he didn't make an error. He was right as to that. Thirdly, he demonstrably failed to consider or misunderstood relevant evidence. Well, in our submission on analysis, that is also not made good, because that seems to go to the medical evidence principally. And fourthly, his decision that Mr. Perry couldn't honestly have claimed in 1999 and thereafter that he was unable to perform the relevant tasks without assistance cannot reasonably be explained or justified. Well, the judge did explain, and in our submission justified, the conclusion he had reached in the light of the burden of proof and the evidence he had heard as to whether or not Mr. Perry would have made and could have made a genuine claim. So in our submission, and to some extent, the fourth conclusion is informed by the first three reasons. Because, of course, if you have, as it were, moved the burden of proof, the way in which Mr. Perry deals with the issues is transformed anyway. So I go on to head on into the Court of Appeal's error so far as the approach to causation is concerned, and this is encapsulated principally under the first two of the reasons Lady Justice Gloucester gave that I've just taken to you. And she starts by saying at paragraph 27, in my judgment, the real issue here is whether it was appropriate for the judge to have conducted a trial within a trial as to whether on the balance of probabilities, Mr. Perry was in fact unable to carry out the relevant tasks without assistance. Well, the error in our submission as to that sentence is the employment of the phrase trial within a trial. And it's a phrase which is often found in particularly professional indemnity claims where, and in the litigation context, claims against lawyers, where a number of the authorities, as you have seen, advance on the basis that the one thing the court cannot do is countenance an attempted trial of the earlier trial in the great majority of cases. And that is self-evidently the case in very many of those cases, because where, for example, in Hanif and Middleweeks, the arson case, the original claim was struck out for want of prosecution or delay in some other respects, by definition, a court has already determined that a fair trial cannot be tried of the underlying claim. And so if it couldn't be achieved at the time the original claim was struck out, the court isn't going to entertain the notion under any circumstances that in the later professional negligence claim, the court can miraculously turn around and try out that matter. And so, of course, it has to be dealt with on the basis of an assessment of the loss of a chance. In other cases, and there are cases, where what might be described as a trial within a trial can occur, either because the underlying claim, which was not advanced, involved simply, I say simply, a construction argument as to an existing document. And there, the trial judge is in the professional negligence claim, where, say, the original action has been struck out under the CPR for non-compliance with a procedural step. The trial judge is in exactly the same position as the putative trial judge would have been. And we don't, in this jurisdiction at least, entertain an argument, well, just because Judge X decided the case in your favour or against you, doesn't mean that if you'd gone to court on a different day and got Judge Y, you couldn't have got a different result. We don't happily have to entertain that debate. So there are cases where there is effectively a trial within a trial, but there are, in the great majority of cases, it's accepted that the authorities deprecate and discourage and say it's inappropriate to take that step. And therefore, the expression trial within a trial, or an effort to conduct a trial within a trial, has taken on a somewhat pejorative sense. And Lady Justice Gloucester here uses the expression boldly. What the trial judge was not doing was conducting a trial within a trial. He was determining, consistently with the approach required of him by the decision of Allied Maples to determine on the balance of probabilities whether Mr. Perry would and could have brought a genuine claim. That was necessarily predicated upon an assessment of merits of his position, because, of course, that issue of causation will always have to be informed by a determination of what the true position was in the judge's assessment on the balance of probabilities. And there are a number of cases that one can easily postulate where that issue of causation will be informed by an assessment, and in some cases a detailed assessment, of the merits of the underlying claim. Can I give you another example? Postulate a claim, it doesn't matter what nature of claim is being brought, by a privately paying claimant. The privately paying claimant does not get appropriate advice from the solicitors and so does not bring the claim within the limitation period. The claim never starts. The defence of the solicitors is, even if I had given you the right advice, I would have had to tell you that your prospect of success was only 20%. It would be open for a judge, and one can see how a judge's reasoning might operate, to say, well, in those circumstances, although I accept that the claim had a potential 20% chance of success, having considered this particular claimant, I do not think this claimant would have invested a very significant investment in court fees and preparations of statements of case to start this case. And in those circumstances, because the case would not have been started, there was no causation. So although the Lady Justice Gloucester criticises clearly His Honour Judge Saffman for taking an assessment of what Mr. Perry's true position was, in our submission, that is something which will be and must be appropriate in determining the issue of causation, limb 2 of the Allied Maples case. So we carry on with paragraph 27. And we see the error in which the Court of Appeal is already drifting into, because at the foot of the page, having said in her judgment the real issue is as to whether it was appropriate for the judge to have conducted a trial within a trial, as to whether on the balance of probabilities Mr. Perry was in fact unable to carry out the relevant task without assistance, which would or might have been a relevant issue in any proceedings against the DTI, had it challenged the assumptions under the scheme that Professor Kester's findings in relation to Mr. Perry's VWF staging meant that he was entitled to a services award. Well, I'm afraid there the Court of Appeal are conflating the presumption with an entitlement. It's short-form language, possibly, but in fact it was not an entitlement. It qualified him. There was a presumption, certainly, that he would not be able to do things, but he would only be able to bring a claim if he had done them before and if he could not do them without some assistance thereafter. The judge clearly thought he was entitled to carry out such inquiry on the balance of probabilities when investigating as a question of causation the issue as to whether Mr. Perry would ever or could ever honestly have brought a services claim. That is right, and that was what the judge was entitled to do. He did not regard the honesty issue as one that should be taken into account by the court at the stage of calculating the chances of success of any such claim. Well, it might have been also to be taken into account then, but it was central to the issue of causation. Rather, he regarded the honesty issue as one which Mr. Perry had to establish as part of what he referred to as the factual matrix. In my judgment, the judge was wholly wrong, both as a matter of principle and in the particular circumstances of the case, to have engaged in the kind of factual determination which he did as to whether, on the balance of probabilities, Mr. Perry could have brought an honest services claim. In reality, the judge carried out a determination on the balance of probabilities as to whether Mr. Perry would have succeeded in his services claim against the DTI.
Well, you would accept that he was entitled to do the first, but not the second.
My lady, yes.
Yeah. So I suppose one question for us in looking at the judge's judgment is which of those two was he doing?
Quite. My lady, and your ladyship and the court will be informed by the fact that, as Lady Justice Gloucester has recited in our submission, the parties had invited the judge to undertake the correct question, answering the correct question, that is to say, the Allied Maples Simmons 2 concession that we discussed at the outset. And in paragraph 27, what Lady Justice Gloucester is describing is that very process. That is to say, the process of the question the judge was asked to determine. She goes on from there to go into the authorities. It might be said that the authorities are not altogether clear as to the circumstances, on the one hand, in which a causation inquiry is carried out in a negligence action, on the balance of probabilities, and on the other, whether any doubts about the claimant being able to succeed are simply reflected in the court's evaluation of the chances of success. With respect, there is no doubt as to or there has not been any doubt as to the Simmons and Simmons approach. It's how we have been approaching such cases for very many years.
Is anybody asking us to examine Allied Maples and
I'm not.
say that Lord Justice Stuart Smith was wrong?
My lady, I don't understand so. Indeed, my learned friend's opening remarks in his written case suggest that we are inviting the court to alter the law.
Well, you're both saying.
So we're not. We are certainly.
You're both saying that your approach is wholly conventional, and it's the other side who is inviting us to change the law.
No, my lady, we're not saying that. I don't think either of us are saying that, oddly enough. We are both seeking to interpret the approach set out by Allied Maples. And I say the Court of Appeal overlooked or misapplied it. My learned friend says, no, they didn't, but you'll determine whether or not he is right. So both of us are seeking to apply the Allied Maples approach. Neither of us are inviting you to overrule it. And our submission, essentially, as we've set out in the written case, is that Lady Justice Gloucester and the Court of Appeal conflated the two issues, the issue of causation, which was an issue pertaining to Mr. Perry alone and therefore was to be determined by Judge Safman on a balance of probability, and the issue of loss, which depended upon, amongst other things, the approach taken by the DTI and the assessors, which was an issue of loss and quantification, which was to be determined by reference to the chance of that claim being successful.
But if honesty comes into 2, there is overlap, is there not, between 2 and 3?
Absolutely. There are circumstances in which the evidence which goes to one will essentially go to the other. And the example I gave you a few moments ago of the privately paying litigant and whether or not he decides to invest in a claim which only has a 20% chance is one of the quintessential examples where there is a very significant overlap in that case. And a great deal of, whilst it wouldn't necessarily be in any objective sense be viewed as a trial within a trial, because what would be being assessed would be the information and judgment which would inform the lawyer's advice pre-issue. But you can see how, almost by definition, that can, in the context of a trial of the professional negligence action, look like a trial within a trial, because it is a self-contained issue. But it is one thing to recognize that in professional negligence, there are very few cases where the professional negligence judge has exactly the same ability to assess that a trial judge of the underlying dispute would have had. And I've lost the sentence, I beg your pardon. There are very few cases where that is available, but there are very many cases in which the underlying material which would have led to a decision in the underlying action has to inform the court. And in assessing the value of a loss of a chance, many of those issues come into play, albeit that it cannot be determined in rem, as it were, between the parties in the same way.
Mr. Pools, can you help me in relation to the intrusion of the word genuine or honest at Allied Maple Stage 2?
Yes.
Which is troubling me a little. If you take a case like Hanif, where there was a counterclaim,
Yes.
That overcame the hurdle of Stage 2, notwithstanding the fact that it was said that it was arson and they'd set fire to the restaurant.
Right.
And so that would suggest that you don't have to consider whether it's an honest claim at that stage. In fact, they recovered, I think, 20% at Stage 3.
That is true. But of course, the question did not arise in Hanif as to whether or not Mr. Hanif would bring the claim. He brought the claim contending, in modern era, he would have had to put a statement of truth on the bottom of his particulars of claim, that he was entitled to the money. And what the court could not do was to determine whether or not he was in fact the arsonist, because the passage of time meant that that was no longer available as a point to be determined by the professional negligence judge.
Thank you.
So there are cases where clearly the genuine question has to be presumed effectively in a claimant's favour because the solicitor's fault has rendered it impossible for that to be tried out fairly. And so the solicitor, having put the claimant in a position where that can't be tried out fairly, can't take advantage of that. But nobody was contending here in front of Judge Safran that that was in any way precluded. And indeed, as you've seen, it was common ground. So if one goes back to Hanif and instead of the actual facts which occurred, you have a circumstance in which for some reason the claim is not issued. So let us say Mr. Hanif went into the solicitors 3 months before the limitation period expired. The solicitors failed to issue in time. The genuineness of whether or not he would have issued would have been open to the solicitors because they were only within the picture for that period of time. There was no difference between the evidence which would be available in the professional negligence claim as would have been available at the time of the advice to Mr. Hanif. And the court could determine in those circumstances whether or not he would have honestly been entitled to bring a claim.
Thank you.
Going back to Lady Justice Gloucester, she then turns to deal with a number of the cases. But on analysis, as you see, the cases are determining the loss question. So she cites a passage from the learned editors of Jackson and Powell dealing with Kitchen. Kitchen was really one of the precursors of loss of a chance claims in solicitors' negligence fields. And she then reads on within the Jackson and Powell, the second paragraph at the foot of page 135, in paragraph 29 of her judgment. If in this kind of action it is plain that an action could have been brought. Of course, that was what was in issue in this particular case. And similarly over the page, the final paragraph there is again dealing with the assessment of loss. It is not dealing with the causation question. And then there's a quote from paragraph 11, 296, under the heading Presumption in Favour of the Claimant. The fact that the defendant solicitors were bringing or intending to bring an action is evidence that they thought it had some prospect of success. Well, of course, that will be the case in many such circumstances, but it wasn't the case in respect of the services claim here. They then go on to deal with Hanif and Middleweeks, and with Dixon and Clement Jones towards the very end of paragraph 31 of Lady Justice Gloucester. And again, these cases are dealing with an assessment of loss. Perhaps it's interesting to look at Dixon and Clement Jones, and there's a very short passage at the foot of paragraph 31. And there, the Court of Appeal held that the causation issue which was being addressed by the trial judge was causation in respect of the claim. It was the defence of the claim. And they weren't prepared, and it had not been argued before the trial judge that that should be read back. So going on from there, Lady Justice Gloucester then reads a long passage from Hanif and Middleweeks, which I have already explained to my Lord Lloyd Jones. And she goes on to paragraph 34. Thus, the correct approach, based on this court's analysis in Hanif and Dixon, is that in a negligence claim against solicitors for negligent omission, as a result of which no claim against a third party is pursued, the court only assesses prospects and awards damages on a percentage basis unless it is overwhelmingly clear on the material before the court that the claimant was almost bound to succeed or had, conversely, only a negligible prospect of success. That is the test of loss. It omits in its entirety the test for causation, which was the question which was determined in the defendant's favour by the trial judge. Going on from there at paragraph 35, she continues, in such a case, a judge should not, in my judgment, in the context of determining in the negligence action the simple causation issue, would the claimant have brought a claim if properly advised, determine on the balance of probabilities what would have been a, if not the, principle in any underlying claim. Well, with respect, in determining the causation issue, as is clear and I don't think in dispute between the parties, the court will take into account all of the circumstances, including the propensity of the particular claimant and the overarching considerations as to risk, and in this case, satisfaction that there is, in fact, a genuine basis for a claim. Here, in my view, she continues, the judge should not have attempted to determine the issue as to whether under the scheme the claimant, in the light of his VWF condition, was genuinely, i.e. honestly, unable to carry out the relevant task without assistance and therefore entitled to a services award. With respect, the judge was perfectly entitled to do that. There are many of these cases where no services claim is brought, despite advice. And that is where people do not consider that they fulfill the criteria. Nor can the defendant raise the issue of the claimant's alleged dishonesty for determination on the balance of probabilities on the grounds that it raises an issue of public policy. Well, again, with respect, that is turning the matter on its head.
Well, how can that be reconciled with paragraph 19?
But, my lady, yes, it can't.
Or is she saying that paragraph 19 was wrong?
She never does say that paragraph 19 is wrong. And what she's... And in many ways, she turns the matter on its head because she's saying the issue of the claimant's alleged dishonesty, the matter is determined by common consent before the trial judge on the basis of a presumption of honesty, not of a presumption of dishonesty. The judge rejects a great deal of the claimant's evidence. That happens in a number of trials for all sorts of different reasons. But this wasn't a trial in which my learned friend was saying the underlying claim would have been dishonest. It was common ground between the parties that the judge was determining whether or not an honest claim would have been brought. So this wasn't an allegation of, this isn't an allegation of fraud or deceit, which requires dealing with in a specific way. It was clear between the parties that the claimant's evidence as to causation was absolutely foursquare in issue. You've seen the witness statements. The claimant and his supporting witnesses put in, I think, a total of 3 witness statements each. The substantive one to start with, and then supplementary witness statements addressing the material which had been produced on behalf of the defendants, which attacked the claimant's ability to conduct himself in certain ways. And there were the Facebook pages which demonstrated that he was wielding a rather ungainly fish and other issues like that. There was no dispute and there was no doubt between the parties at trial that the claimant's abilities for the purposes of a services claim were absolutely foursquare in issue. And it's clear, as you will have seen from the judgment of Judge Safman, that he dealt with that issue and expressly dealt with the question, is this a novel issue? No, it isn't. This is what the parties clearly came to this court to resolve. So she goes on from there in paragraph 35 to add some further reasons for her departing from the trial judge and her determination, Court of Appeal's determination, of what ought to have been decided. There are sound public policy reasons for such an approach. Such an approach, presumably in this case, being effectively to elide the question of causation and loss. It is far too easy for negligent solicitors, or more pertinently, their insurers, to raise huge obstacles to claimants, such as Mr. Perry, from pursuing their claims, if the latter are required effectively to prove in the litigation against solicitors that they would have succeeded in making a claim against the third party. With respect, that isn't what the trial was determined about. I can't assist you with why it is thought that it is easy for negligent solicitors to raise huge obstacles. It is certainly the case that tortfeasors of all kinds raise defences in these courts, as they are entitled to do. And it is certainly the case that there are many cases where lawyers face evidential problems, and the classic example is that identified by Lord Justice Simon Brown, as he then was in Mount and Barker Austin, where he says the solicitor who has told his client you've got a good case is going to have great difficulty coming in front of the trial judge in the professional negligence action and saying the case was rubbish. That is certainly true. But how that makes it easy for solicitors or lawyers to raise huge obstacles, I cannot assist you upon. And what was not being required by Judge Safman for the claimant to get past the causation hurdle was for Mr. Perry to prove that he would have succeeded in making a claim against the third party. What he had to prove was that he would have brought an honest claim against a third party. She continues, Raleys' defence in the present case is an unfortunate exemplar of insurers putting the claimant to proof of every issue in the underlying claim. Well, that is a statement of opinion. It's not particularly pertinent, but it does, in our submission, inform the approach that was being taken by the Court of Appeal. Such an approach is intellectually unsound. It requires the court inevitably many years later to investigate whether a claimant who, as here, may be unsophisticated and not have kept records, to prove what he would have done many years earlier. Well, it is true that in very many cases that come before the courts involving a number of different issues in the law of tort and otherwise, claimants have to discharge a burden of proof as to what may have happened some years ago. That is the system which I'm afraid we have to operate on. In the modern era, we try and abbreviate the period between the underlying events and the trial as much as we can, but it's always going to be a problem. Every judge in the land knows it, and every judge in the land finds his or her way through the problem of taking that difficulty into account when he or she determines the credibility of the party and the witness before them. She continues, in cases of admitted or proven negligence on the part of solicitors or other professionals, that should not be the correct approach, nor, in my view, do the authorities support it. Again, in our submission, there is nothing in authority or otherwise that separates professional defendants from any other form of defendant in a tort case from the overarching principles of fault, causation, and loss.
It almost sounds as if she's adopting a Fairchild type approach.
Well, possibly. Perhaps that was the elephant.
Because you've got a breach of duty, but it's difficult to prove causation,
Yes.
let's just abandon that principle.
And where she says solicitors or other professionals, it would of course be open for this court to hold that in professional negligence actions the issue of causation is dead. It would be a rather significant departure from existing authority throughout the common law world, but it would be theoretically possible. But it rather does beg the question, well, for these purposes, what is a professional? And why should the liability of a lawyer or an accountant be any different from the liability of a local authority in respect of a tree that falls down, or in respect of any other group of people providing services for consideration?
I don't think you're facing an argument that there should be a special rule for professionals.
My Lord, I'm grateful for that, and I won't wax lyrical any further, but it does in our submission inform once again the fundamental error of the approach of the Court of Appeal in this case. Because this is a paragraph that reads like a court which is trying to conclude that there is effectively a different approach to the law of tort generally. And she continues. Well, perhaps before parting from that, I should perhaps add what it would amount to would be an assumption of honesty, an assumption of accuracy, and in very many professional negligence claims, an assumption that a claimant would have taken whatever course affords him the opportunity to the most recovery against the professional, without consideration of the issue of causation at all.
I mean, we mustn't be blinded by the possibly unfortunate concession that the plaintiff, the claimant, had to prove that an honest claim would have been made. If that was wrong as a concession, we've got to, I mean, we can't have this case go off on the basis of a concession unfortunately made.
Absolutely right.
And so we'll have to ask ourselves, what would actually be wrong in putting the question of honesty into question 3? You say it would be contrary to Allied Maples.
I suppose it could be in both.
I think the answer is it remains a consideration for question 2 in any event, because most people would not do something which was dishonest. No. And therefore, a judge deciding whether something would happen would be bound to say to him or herself, to do this would be dishonest. And therefore, 98% of the community would not do it. Do I think this claimant would have done it? It almost puts the judge in the rather invidious position to say, well, I consider that to do this would be dishonest, but I consider this is a dishonest person and therefore he or she would have done it. I think when you consider it in that way, you can see why, in reality, the presumption firstly is one that the courts would not wish to entertain, that is to say, doing something which says, well, we are going to give you an opportunity for compensation in respect of a claim which we conclude could not honestly have been brought. That has a public policy consideration. And when you go through the processes I've just done of trying to see the reasoning which would take the judge, you can see how offensive it would be. You are effectively rewarding the claimant for concluding that he is or she is a dishonest person. I think the law would always cavil at that.
Well, would you be rewarding him if, in fact, he's going to fail at the third hurdle?
Well, but the difficulty with that, of course, is once you get to the third hurdle, you are dealing with circumstances where even a dishonest claim may attract a settlement from an insurance company. I mean, the courts are much troubled in recent years by fraudulent road traffic claims. Postulate the case where one of these groups comes to the solicitor and the solicitor fails, who isn't on this occasion involved in the fraud, fails to issue the claim form in time. The case comes before the courts and the claimant says, well, I would have recovered 30% of my claim at the very least. And the solicitor has got the video of the crash for cash CCTV, which demonstrates that it would have been a fraudulent claim. In those circumstances, can the claimant be heard to say, well, I would have issued in any event, regardless of my solicitors telling me I had no claim, had that been open to them to tell them? And if I had issued the claim, the insurers would have been so terrified by the possibilities they would have paid me 25%. That is a claim which, in our submission, as a matter of public policy, the courts do not accept.
Now, putting it very shortly, the law of professional negligence in this context requires, in addition to breach of duty, proof that something has been lost, and that something is limited to honest claims.
Quite so.
Not dishonest claims.
Quite so. And it is right, and Justice Lloyd-Jones raised the question of Hanif. Sometimes people point at Hanif and saying, well, even a dishonest claim may attract an award in the professional negligence context. And that is a misreading of Hanif, because Mr. Hanif was going to have very considerable difficulty, but it was not open for the professional negligence court at the instance of the defendants to find that he was a dishonest person, because by definition the totality of the evidence was no longer available to Mr. Hanif. So there you can understand why the issue plays out in a slightly different way. But Hanif isn't a case of a court benefiting somebody who is dishonest, because that issue cannot be tried out. Moving on. Paragraph 37, the Court of Appeal moves on. Thus, in the present case, there was, in my judgment, no way in which rationally the judge could have regarded this as a case in which it could be said that it was overwhelmingly clear on the material before the courts, certainly not before the trial began, and even after all the evidence had been heard, that the claimant had only a negligible prospect of success. Well, with respect, that is Lady Justice Gloucester reformulating the test and putting effectively onto Judge Safman's judgment a test which he was rightly not applying. The medical reports of Professor Kester clearly supported Mr. Perry's case that unless the DTI rebutted the assumption, Mr. Perry satisfied the factual matrix for a services claim under the scheme as it evolved. With respect, no. Professor Kester's reports gave rise to the medical presumption of the inability to perform various tasks. A claim would require evidence that they had been performed in the past and they could no longer be performed after the VWF in the future. It was only then that the DTI, if such a claim was put forward, that the DTI would have to rebut it. So again, Lady Justice Gloucester and the Court of Appeal are removing the central issue factually to the causation question. Likewise, she continues, the subsequent evidence of the jointly instructed medical evidence, Mr. Tennant, clearly supported Mr. Perry's entitlement to a services award. Again, it's the wrong verb. It supported the medical presumption and nothing more than that. And she continues, Facebook entries dating from 2011, i.e. some 10 years after any claim would have been made, showing Mr. Perry holding a fish on a fishing holiday, did not on any basis justify a factual inquiry as to whether Mr. Perry could have honestly made a claim in 1999.
I think Judge Safman, reading that, would have said to himself, that is a parody of all the evidence to which I was referring.
My Lord, yes.
But how far that gets you, I'm not quite sure.
Well, the relevance is this. Judge Safman had to deal with the evidence as presented to him. As he says in his judgment, once somebody has developed VWF, their condition is static. generally speaking, save in the most exceptional case, you don't deteriorate and you don't improve. And so if you are examined 10 years after the claim, the presentation you make is the same as it would have been at the time of the claim. The fact that Mr. Perry can hold up the massive carp 10 years after the event was telling evidence as to his lifting ability, his disposition to go fishing and to deal with cool, warm, hot water. And there was no expectation that that would have changed over the 10-year period. So Judge Safman would have said, not only is this somewhat excessively dismissive of the process I went through, it fails to understand how Mr. Perry is performing 10 years after informs both his credibility, because of what he has said in his statements, but also his abilities. She continues, reading the judgment as a whole, I have no doubt that the exercise on which the judge embarked in relation to the causation issue was in reality an inquiry as to whether, if the DTI had challenged the services claim, the claim would have succeeded. Once again, with respect, that wasn't what the judge was doing. He identified the right question and he answered the right question. In effect, the judge asked himself the question whether, as at the date of the trial in 2015, he was satisfied on the balance of probabilities that Mr. Perry had established that he couldn't carry out the relevant services claim without assistance. Effectively, whether he could have made a successful claim. Again, that is not clearly what the learned judge was doing. The reality was that the judge, on his analysis of the facts, approached the determination of this question on the basis of what he found Mr. Perry was able to do in 2015. That was not the right question. Well, again, you've seen Judge Safman's judgment. He doesn't approach it on the basis of what Mr. Perry was able to do in 2015. He reviews a long history of complaints to various doctors, Department of Pensions, applications for invalidity benefit, the descriptions Mr. Perry has given of his disabilities over the years, and most tellingly, his cross-examination and his inability to explain a number of significant disparities in the accounts which he has given. All of those matters are the matters which inform Judge Safman's conclusion as to causation. And the Court of Appeal clearly do not do him justice in this misrepresentation of the process as they read it. The court then goes on to consider what they describe as the right questions. The right questions were, first, whether, as at the date of the settlement in 1999, Mr. Perry, if properly advised, would have acted differently and made a claim for a services award. That question did not involve an inquiry as to whether such a claim would have succeeded. In my judgment, the answer was obvious. Mr. Perry would and could clearly have made a claim. Well, as we set out in our reasoning, it could properly involve an inquiry as to what Mr. Perry's condition and disabilities were, because the answer to that question would inevitably influence the judge's determination as to what Mr. Perry would have done. And the submission that the answer was obvious, I'm afraid, is dismissive of the trial judge's consideration of the evidence which he'd heard at some length from Mr. Perry and his family.
You would agree that the question's the correct one. What you don't agree is that the answer
exactly
given.
Lady Justice Gloucester at this stage does reformulate a causation question. The C word isn't used, but the problem is the second half of the paragraph then makes it into a loss question. And then second, if Mr. Perry had in fact made a services claim, what would have been its chances of success? that claim for loss of a chance didn't fall to be determined on the balance of probabilities. Correct. There's nothing between us on that. In my judgment, although the judge approached and answered the second question correctly, his approach and answer to the first question was wrong. In reality, he investigated and purported to answer, on the balance of probabilities, the question whether Mr. Perry could have made a successful services claim if the DTI had challenged it under the scheme. Again, with respect, that wasn't what the judge was invited to do, and it wasn't what he did. He did so without regard to the critical feature as to what was the appropriate date for such analysis. For that reason alone, I would allow this appeal. Again, in our submission, the judge had the proper question clearly in his mind and clearly went about it in the right way.
So what is this date point then?
Well, I think it's the CARP, because he was taking into account what Mr. Perry was clearly doing in 2015. He was reading back, or not reading back, or was conducting a current assessment. It's the point that's made at the foot of the paragraph 38 before the indents. The reality was that the judge, in his analysis of the facts, approached the determination of this question on the basis of what he found Mr. Perry was able to do in 2015.
Thank you.
And she then goes on, and the court goes on to consider the judge's errors in other respects. It wouldn't be appropriate to remit the case because, irrespective of the fact the judge adopted the wrong approach to determination of the relevant issues, the judge clearly went wrong in his assessment of the evidence relating to Mr. Perry's ability to make a claim. For that reason, I'm satisfied that this court can, in the circumstances of this case, overrule the judge's findings in relation to causation and conclude, consistently with the judge's findings as to loss of a chance, that Mr. Perry has lost a chance with an 80% success rate. Then she sets out her further errors. First, the judge appears to have taken the view that the burden of proof was on Mr. Perry to establish that he would have been acting honestly in making a claim. Well, the burden of proving causation was on Mr. Perry. And that was to establish on the balance of probabilities, as we've seen, that a claim would and could have been brought, which would have been honest. As I've already said, whether or not Mr. Perry would have succeeded in making an honest claim was not an issue for the judge to decide. Again, it's eliding the two issues. The judge has taken her eye off causation and has gone back to assessment of the underlying merits of the loss of a chance. Insofar as Raleys were contending that Mr. Perry would have been dishonest in 1999 if he had claimed a services award, and that factor should have been taken into account in assessing Mr. Perry's chances of success, the burden of establishing that Mr. Perry, even if he'd been told about the availability of the services award, would not or could not have made a claim, because it would have been dishonest of him to have done so, lay fairly and squarely on Raleys. With respect, no. That is misrepresenting and reversing the issue to be determined. The issue was one of causation, rightly identified by counsel, rightly presented to Judge Safran, and rightly decided by him. And that was because it was on Raleys as the party making the assertion of dishonesty to prove it. Well, again, it's reversing what was in fact going on here. Everybody was assuming that Mr. Perry would not act dishonestly in making a claim. So there's no reversal of any burden of proof. And she continues, it was also because in the circumstances of this case, the medical reports of both Professor Kester and the joint expert, Mr. Tennant, gave rise to the presumption, not just under the scheme, but also evidentially, that Mr. Perry's particular level of VWF staging prevented him from carrying out the relevant services, and that accordingly he would have qualified for a services award under the scheme. Again, I've made the point, I make it again, that presupposes the factual matrix rightly identified by Judge Safman. You cannot move seamlessly from the medical report to an award. In those circumstances, there was a heavy evidential burden upon Raleys to prove their allegation that he would never have made a services claim. I have the metaphorical ghost of my evidence tutor at my shoulder, because Lady Justice Gloucester here is eliding a burden of proof and an evidential burden, which are, as the court will understand, very different things. Moving on, although the judge in paragraph 133 of the judgment paid lip service to the notion that even if the burden had been on Raleys to establish its assertion that the claimant didn't meet the matrix, it has discharged that burden. In fact, he gave no or no adequate reasons for reaching the conclusion that Raleys had discharged the burden of proof. Well, he certainly didn't do that because he didn't accept that, but he accepted his assessment of the evidence as a whole was that he was clearly satisfied to a high standard that Mr. Perry would not have brought and could not have brought an honest claim. Going on from there, there are a number of points which, in my judgment, the judge failed to appreciate. Although, along with every other possible defence, paragraph 15A of the defence put Mr. Perry to strict proof that he'd in fact suffered with HAVS to the extent contended for, and paragraph 16.1 averred that he had failed to establish that he had a requirement for the provision of the relevant services and was in fact in receipt of assistance for them, there was no express allegation of dishonesty in the defence. And such was not required. On the contrary, the thrust of the defence on any objective reasoning was that the defence was going to argue that it was Mr. Cronick's back pain that was the reason why he would have required assistance with the tasks covered by the services claim. That was certainly one of the reasons relied upon in support of the contention that causation was not made out. Although the service of Raleys' solicitor's statement would have made it clear that the defence were challenging Mr. Perry's alleged functional disability, nevertheless, this was a case where if serious allegations of dishonesty were being made, it should have been made absolutely clear to Mr. Perry in cross-examination that such was the case. With respect, you've seen the transcript of the cross-examination. It is made perfectly clear to Mr. Perry in a number of different places and in a number of different respects that he was not disabled by the VWF so as to qualify for a services agreement, and that he was in fact limited, if limited at all, by reason of back problems. And the learned judge dealt with the question of opportunity to deal with the question of Mr. Perry's evidence in his judgment and was satisfied that there was proper notice in all respects. This wasn't a case in which there was a positive allegation of dishonesty or deceit or fraud. This was a case where the defence actually asserted Mr. Perry's underlying honesty.
Yes, but not his honesty in the witness.
Well, no, in the same way that in so many cases.
Well, yes.
And that isn't something that has to be predicated.
Yes, I think the defence is stated at 878 in Appendix 2. What is stated is it is submitted that as a matter of fact, he is not likely to have lodged such a claim in any event on the assumption that he was acting honestly, and that this conclusion therefore disposes of the claim in its entirety.
Yes.
So you say that the question of causation based on an honest claim was at least put in the defence.
Absolutely right. Yes. And as we allude to briefly in the written case, it would be a very foolish defendant that would unnecessarily allege dishonesty in a case of this type.
Yes, because I mean, what Lady Justice Gloucester says is there was no express allegation of dishonesty in the defence, i.e. that it would have been dishonest for Mr. Perry to have made such a claim.
Right.
That doesn't seem to tally with
No.
the passage I've read out to you.
And what is more, it wasn't necessary to make, as it were, an allegation of dishonesty because one was presuming that he would be honest.
Yes.
I put it to you that he would have been honest is not an assertion that you have to make to a witness.
No, but the cross-examination would have had to have conveyed to
Absolutely.
Mr. Perry
And
the proposition that insofar as he was telling the judge that he did suffer from disabilities of the specified kind from which he had not previously suffered, he was not merely not telling the truth, but he was lying.
And your lordship has seen the cross-examination, and it deals with a number of issues of which the carp is one.
Well, the carp's the one that sticks in mind, I suppose.
Yes.
Are there particular passages in the cross-examination which you found?
Yes. It is actually
Your approach is quite interesting, Mr. Pools. You're taking us line by line through the judgment of the Court of Appeal, which we have all read, while assuming that we have read the transcript of the trial, which we almost certainly have not.
But, my lady, I have that in mind, and I was going to
Well,
finish
you said
with the
we'd
flow.
read it. Well, frankly, it's not common practice in this court for us to have done that, whereas it's absolutely common practice for us to have read the judgments.
My lady, if you'd like me to go straight to Saffron, I'm very happy to do so.
No, we have done that, but my lord asked you, what passages in the cross-examination are you relying on? That would be of some assistance
But,
to
my
us
lady,
all.
I understand that entirely. In fact, we have identified in the skeleton the crucial passages. If I can take you to those references, and I'm obliged to my learned friend for pointing me in the right direction quickly. We start on page 192 of the bundle. And I'm afraid there are extensive passages.
Mm-hmm.
And at D, he is being asked about, you remember having backache in 95? And he says, oh, he remembers going to the physio. That was after you'd left work. And that was because you had back pain after you left work. What we don't see anywhere is any reference to the problems you say you were experienced due to difficulties with your hands, do we? No. This was a problem that you say that from the period you were in work had been causing you problems with one of your main passions, which was fishing. If it was that real, you would have told your doctor, would you not? No. You've gone to see him about stomach problems, yes. You've gone to see him about knee problems, yes. You would have gone to see him about your back problems later. You don't mention anything about your hand problems, do you? No. Why is that? Well, because I don't know, to be honest. The only thing I can think of is that it were just a known thing that you had your fingers were a problem at work. Equally, it was not something that was causing you the same problem as, for example, an injured knee or an injured back. It was not stopping you from doing things, was it? Wasn't stopping me. The difficulties you describe in your hands at work, no. It wasn't stopping you, for example, gardening, was it? No. 1992, no. It wasn't stopping you in 94 or 95 when we were looking at the references we're looking at now, wasn't it? Sorry, wasn't it? Well, I'm saying it was not. Right. Which is why you didn't mention it to your doctor. Right. What is your response to that, Mr. Perry? Because it was just an illness, an injury I'd had, which something from work. Well, lady, that's one of the passages. There are a significant number. The references, by reference to the transcript, are in paragraph 30 of our written case.
Page?
page, oops,
71, I think.
71.
Yeah.
Sorry, I'm not getting the references correctly, obviously. You say that they're in paragraph 13 of your case.
30, 30.
30.
Zeros. I'm sorry.
I misheard you, sorry.
And that was a short example. It does extend over an extended period.
Yes, I see the passages are mentioned there, yes. Thank you.
We are. Well, we can look at those in our own time. But thank you.
Lady, not at all. I apologise, going back to Lady Justice Gloucester, paragraph 46 deals with further criticisms of the approach of Judge Safman. Mr. Quinney's cross-examination amounted to an extensive analysis of some, but certainly not all, of the various historical medical records going back many years, in which Mr. Perry had made complaints about various matters and in particular back pain. It was perhaps not surprising that an unsophisticated witness such as Mr. Perry, who the judge did not regard as an impressive witness, had little recall and was unable to give satisfactory explanations of what had been said to various medical practitioners so many years ago. Indeed, this was one of the obvious vices of the approach which the judge adopted in effectively trying the issue as to whether the claim would have ultimately been successful. In my judgment, the judge placed far too much weight on the detail of the inadequate answers which were given by the appellant in this respect and failed adequately assess in the light of all the evidence whether Raleys had actually proved what amounted to the very serious allegations of dishonesty. Again, the same error is apparent. And indeed, it is a passage which in our submission is redolent of the warnings given by this court in the past about the difficulties of island hopping in assessment of transcripts, where the judge at the trial has the ambit of the aspect of the whole sea before him. This judge was clearly wholly unimpressed by the evidence of the claimant and his family, and analysed it, as we will see in a moment, very carefully before reaching the conclusion to the correct question, not the question as reformulated by Lady Justice Gloucester. Moving on to the appellant's second ground of appeal, the Court of Appeal continues, I conclude the judge gave no proper reasons for disregarding the reports of Professor Kester or Mr. Tennant as to Mr. Perry's disability, and for basing his view on the very anecdotal evidence of Mr. Perry and his witnesses, almost exclusively by reference to his cross-examination at trial on past medical records and Facebook entries, topics to which I will return in due course. In particular, I conclude the judge demonstrably failed to consider the effect of Mr. Tennant's evidence, which had been specifically obtained in the context of the litigation as a result of His Honour Judge Hawksworth's direction that Mr. Tennant should be instructed as a joint expert to prepare a report. And in my submission, as we will see, the judge had Mr. Tennant and Professor Kester's evidence well in mind. That was particularly surprising, the Court of Appeal continues, given that pursuant to generic case directions, Mr. Tennant had been instructed to prepare a report stating his opinion as to whether the claimant is and was at the time of the onset of HAVS symptoms disabled by HAVS as a matter of fact, and to the extent that he was unable to carry out in whole or in part without assistance the tasks which he alleges would have formed the basis of his services claim. Well, that is what the direction says. The report is there. The report doesn't actually, quite rightly, embark upon the process which it was for a court to determine. And all that Mr. Tennant was able to do was to recite what he had been told by the claimant and what he determined as a matter of medical evidence. It was for the judge to determine the issue, and it was certainly not for the judge to devolve the determination of the issue to Mr. Tennant. And going over the page, in further support of the importance, in the Court of Appeal's view, of Mr. Tennant's findings, at the bottom of page 144, it's clear from Mr. Tennant's disability grading schedule contained in his report.
Sorry, which paragraph, Mr. Poole?
Sorry, paragraph 50, my lord.
Very bottom of the page. Yes.
Very bottom of the page. Mr. Tennant's grading schedule contained in his report, which only in respect to car maintenance states that his views were based on Mr. Perry's statements. In my judgment, if Raleys were seeking to assert that the expert views of Mr. Tennant as a jointly instructed expert in relation to this specific issue of disability could not be relied upon, because they were exclusively or materially based on Mr. Perry's own statements. And what mattered was the judge's own views of the credibility of Mr. Perry in cross-examination as to whether he could or could not perform the relevant tasks without assistance. Raleys should have insisted on Mr. Tennant having been called as a witness and cross-examined him to that effect. Difficult to actually understand what form such a cross-examination would have taken place, because the issue was that which was that to be determined as part of the causation issue by the judge, and most of us present in the room have on occasions heard a judge say to an expert witness, well, I'm interested that you have this view on this question, but the question is, for me, I'm interested in the views on which you have expert opinion, that is to say, in Mr. Tennant's case, the extent of disability. Whether, in fact, there is a services claim, because factually the factual matrix is made out, was never a matter for Mr. Tennant, regardless of the intention of Judge Hawksworth. Court of Appeal, continuing at paragraph 51,
Who persuaded Judge Hawksworth to give that direction, I wonder?
My lady, the direction was made generically in 2011. At a very, it's been the
indirectly, it has led to both of the cases that are coming before this court.
Indirectly, it's led to a lot of cases. Yeah. It's an excellent illustration of how difficult case management is. I think at the time Judge Hawksworth was managing, the iceberg was apparent. Scale underwater was not. And I think both parties would have agreed some years later that there were bits of it which they would have done differently. But certainly, in our submission, the Court of Appeal's promotion of it as an issue which seemingly gave Mr. Tennant's assessment of this crucial issue a significance beyond his expert evidence is one that cannot be made good. And as I say, it is one which most of us have heard roundly seen off by a trial judge confronted with an expert being asked by adventurous counsel a question which it is very much for the judge rather than the expert to resolve. So paragraph 51, Lady Justice Gloucester continues, in the absence of any such cross-examination, I regard the view of the judge as to what he regarded as the critical question, for him to answer as unsustainable. The judge said, I acknowledge the staging of 2 doctors supports the view that he has a significant loss of function, but I repeat that the question is whether the claimant has established that in reality any loss of function manifested itself in an inability to carry out the tasks. That is a question of credibility. Now, Lady Justice Gloucester considers that these passages are unsustainable. In our submission, they are absolutely correct. Apart from the fact, paragraph 52, apart from the fact that, as I described it, the judge was clearly adopting the wrong approach to the determination of the relevant issues, it is clear that the judge based his conclusion entirely on what, on any basis, was a partial and unsatisfactory cross-examination of Mr. Perry. Well, not retained by my learned friend. The court will have an opportunity to review the cross-examination. Impartial cross-examination is an unusual creature in any adversarial system, but it was polite, appropriate, phrased for a gentleman who was, by common consent, relatively unsophisticated and patient.
Well, partial could mean not complete.
It could.
Rather than not impartial.
Possibly. I'll accept.
Well, I don't recall many impartial cross-examinations in my time in practice.
They can be remarkably effective, however.
Yes.
But I accept what your lordship says.
Oh, yes.
Based on anecdotal evidence, anecdotal evidence is the evidence of the individual, and historical incomplete records of visits to his general practitioner. In coming to this conclusion, the judge demonstrably failed, in my judgment, to give due weight to the medical evidence. Again, the medical evidence was what the medical evidence was. It was a necessary precursor to any services claim.
Yes, but the medical evidence did include a finding of markedly impaired, whatever moving 2-point discrimination is, and it also included dexterity is severely impaired bilaterally.
Exactly. And that's why there's a presumption.
Yes.
If there wasn't that presumption, we would never get to the possibility of a services claim. And my lord...
And he did, Dr. Tennant did also, Mr. Tennant also did, at page 506, conduct his assessment of disability grading in relation to gardening, window cleaning, car washing, etc.
Yes, well, of course...
But based on what he'd been told.
Exactly so.
But he obviously considered that consistent with his findings on such things as dexterity.
Of course, and nobody resiles from the fact that the grading gives rise to the presumption. So what, in fact, Mr. Tennant is doing there is reciting the consequences of the grading which he concludes by reference to the 5 different types of services.
But Professor Kester, in what, 1997?
1907.
Long before the service claims
Yes.
Arrangement came in, was actually talking about manual dexterity.
Yes, but of course, and that's what VWF is all about. So the fact that there is the presumption arises because, amongst other things, manual dexterity can be affected by the process. And then you get into the process of what you did, what you don't do, what you managed to do, what you don't manage to do. But
Yes.
the medical evidence is the medical evidence, and the scheme and the medical evidence presumes the same thing. That is to say that the individuals have a presumption because of their grading.
Yes, but it's not just that. I mean, if the medical evidence is accepted as accurate, then whether or not he complained about his condition to the GP doesn't call into question his medical state. He had this lack of dexterity.
My lord, yes, but as you'll see when you look at the cross-examination, one of the issues my learned friend was taking was, even before you know you have VWF, if you are not able to do the gardening or the fishing because of dexterity, why aren't you going to your GP or saying to your GP when you go and see him, there's something wrong with my hands, I cannot do this anymore, if you can't do it anymore. Of course, once you know you've got VWF, well, then it's entirely explicable that you don't ask that question because, you know, you've been told there's nothing that can be done about it. But at the earlier stage, when he was first giving up these interests and hobbies, it was common ground that he didn't know he had VWF. And that was why it's so telling that he is not, and Mrs. Perry was cross-examined, as you'll have seen, along the lines of, well, didn't you ask if your husband wasn't going to, I think, garden anymore, didn't you ask him, why not ask the GP whether there's anything that can be done? And that was clearly all influential in the overarching conclusion reached by the trial judge. We then go on to deal with it's open to the trial judge to reject the evidence of the single joint expert. An example is given. But there was in the Court of Appeal consideration no proper consideration as to the basis on which, or for the reasons why, he was disregarding what was the compelling evidence in Mr. Perry's favour as to his disability in performing the relevant task without assistance, particularly in the absence of any cross-examination of Mr. Tennant. Had he considered the matter, he could not logically have come to the conclusion that such medical evidence should be disregarded in its totality in assessing Mr. Perry's honesty. Well, again, in the very paragraphs Lady Justice Gloucester has just cited and recited at paragraph 51, the learned judge has not disregarded the medical evidence in its totality. He has recited that there is a significant loss of function. But he has then gone on to deal with the issue which is not for the doctors, that is to say, the issue of credibility. She then goes on to accept the judge appears to have misunderstood or failed to apply a principle which was fundamental to the scheme, namely that a claimant didn't have to be disabled entirely from carrying out a task. With our respectful submission, the judge did not make that error, and it will be clear from his judgment in a number of passages that he did not. And if I can give you the references, we'll come back to them later, but it's in paragraph 30 at page 161, paragraph 121 at 176, paragraph 130 at 177, and I think most significantly, paragraph 132 at page 178. Paragraph 55, I also accept Mr. Watt-Pringle's submissions in relation to grounds 4 to 6. The judge, in my opinion, could not rationally have reached the conclusion that Mr. Perry, his wife, and his two sons had all given false evidence. The conclusion was not justified on the basis of what, on any analysis, was flimsy evidence relating to the Facebook evidence and speculative and assertive cross-examination about the fishing trips or Mr. Perry's ability to perform the other tasks. I consider the judge was wrong to infer that serious adverse inferences could be drawn from the absence of witnesses of other people who were involved in the fishing trips. The fact that a man suffering from VWF may be unable or find it difficult to attach a fly or a lure to a fishing line does not mean he is unable to hold a fish or indeed to participate to some limited extent in a fishing holiday. Likewise, the selective cross-examination of certain inconsistencies and variations in the details of what Mr. Perry had said or reported to have said on various occasions and in various medical records over a period of nearly 20 years since 1996 about events going back even further to 1992 when he first began to have symptoms of VWF could not rationally have justified the judge's conclusion that Mr. Perry would have been acting dishonestly in making a services claim. With respect to Lady Justice Gloucester, she is doing exactly what the Court of Appeal should not do. She is preferring her assessment of the witnesses to the assessment of the trial judge who heard them. She repeats the same in paragraph 56. I don't propose to deal with it further because it is simply a roundup. I now propose to take you very quickly and clearly belatedly to the judgment of Judge Safman. He introduces the matter He deals with the admission of liability at paragraph 10.
Can we have a page number?
I do beg your pardon. Page 155 is the commencement.
Thank you.
And on page 156 at paragraph 10, he sets out the admission of liability. Recites the limitation defence, and then starts to set out the medical evidence. Paragraph 12, for his part, the claimant doesn't dispute that he suffered from a comorbid condition, namely a back problem, and that accordingly he wouldn't have been entitled to the full tariff amount of the services award. A single joint expert instructed by the parties, Mr. Tennant, has concluded that until about mid-1998, the back pain was a moderate contributor to the claimant's inability to undertake the services, but from mid-1998, its effect on the claimant's inability to undertake the services was only mild. Mr. Greenbaum and Mr. Quinney respectively have assured me that armed with that information, the services award that would have been payable if the factual matrix were met can be calculated. I should add, however, that that is without prejudice to the defendant's contention that the back problem was not a comorbid condition that contributed to the claimant's inability to perform the tasks that the services award was designed to compensate, but was rather the entire reason he was unable to undertake those tasks if, and this is not conceded by the claimants, he was indeed unable to undertake them. Mr. Quinney accepts that such a finding could not be consistent with the conclusion of Mr. Tennant, the jointly instructed expert, but he reminds me that I am not bound to accept his conclusions, and for the reasons I shall come to later, I should not do so. So right at the outset, the judge has it clearly in mind that what he is being asked to do is to depart from some of the conclusions of Mr. Tennant on the basis of the evidence which he will hear. Mr. Greenbaum accepts, as counsel for the claimant, that if I find the back problems eclipsed, as Mr. Quinney described at the VWF, and that in the circumstances it was his back problems that stopped the claimant from performing the relevant tasks, and not the effect of VWF, then the claimant has no claim, because in those circumstances he doesn't meet the factual matrix, which requires that the claimant could not undertake the tasks by himself by reason of his VWF. In short, the issues for determination are: 1, statute bar; B, if not, whether the admitted breach of duty caused or materially contributed to the claimant's alleged loss. In the context of this case, did the breach cause the claimant to settle his claim at an undervalue because on balance, if properly advised and on the assumption that he acted honestly, he would have made a claim for a services award? On the basis of Mr. Quinney's analysis of the issues, this and C below essentially boil down to a determination of the question of what level of disability the claimant suffered, the extent to which it prevented him from undertaking the services tasks, if at all, and whether any disability was caused by his back problems rather than VWF, or a combination of VWF and back problems constituting a comorbidity. C, has the claimant lost something of value in the sense that his prospects of success in a claim for a services award were more than negligible? D, if the claimant has lost a claim with more than a negligible prospect of success, what is a realistic assessment of the prospects of success were? E, it's a slightly different way of putting D, what's the appropriate assessment of the likely value of the claim, having taken into account the prospects of success. So the trial judge correctly identified causation and assessment, and correctly in our submission identified that issues pertaining to the assessment would inform issues concerning causation. And then he gives credit to Judge Gosnell and the earlier case of Barnaby's as being a significant contributor to his identification of the issues. He then deals with a history of similar claims, and he identifies that he and other judges have had to deal with the contention that the defendant firm was aware that minors as a cohort were typically unsophisticated, uneducated, unreliable historians and poor with paperwork, and it was incumbent upon the defendant to tailor the manner in which they sought instructions and the manner of their advice to account for that. The system adopted by the defendant to process these claims negligently failed to make allowances for that. So although the judge is, as it were, identifying the claimant's cohort difficulties by reference to the defendant's liability, what is clear from that passage is that the judge has the difficulties which Mr. Perry and his former co-workers have well in mind. Lack of sophistication, lack of education, etc. And that's right at the forefront of the judgment. As will be obvious, that contention's generally been offered in support of the allegation. Mr. Greenbaum has made the point, however, that that contention does not become irrelevant merely because, in this case, breach of duty is not an issue. The defendant's case that the claimant has suffered no loss as a result of the admitted breach is premised on the basis that the claimant in any event failed to meet the factual matrix. This is a question of fact, and in support of its contention that the matrix was not met, contrary to the position of the claimant, the defendant attacks the credibility of the claimant, not least by reference to inconsistencies in documents and the claimant's recollection. Mr. Greenbaum argues that evidence about the intellectual and or clerical acumen of minors generally remains important, whether the claimant is honest, in assessing whether the claimant is honest and doing his best or dishonest. So again, the judge has that issue squarely in the forefront of his mind as he embarks upon the judgment. And he then recites further findings from the Solicitors' Disciplinary Tribunal in that regard. He then deals with...
Do you say we should take it from reading 17 and 18 together that the judge was, at least by implication, saying that Mr. Greenbaum's argument about the relevance of intellectual to credibility was a proper one?
Yes, my lord, yes. He then spends some pages dealing with the detail of the compensation scheme. I only need to take you to paragraph 25 because it's the brief summary of the actual matrix, which has been referred to. That's at page 160. And then at paragraph 34 on page 161, he deals with Mr. Perry's claim. At the top of page 162, he recites paragraph 37, Professor Kester's report and its findings. Paragraph 40, he sets out the maximum level that the claim could stand at. Still on page 162. And paragraph 41, he sets out the claimant's contention. That's to say that he was entitled to make the claim for services since he has needed and received assistance with all the tasks for which the scheme provides accommodation since 1994, and that such assistance has been provided by his sons and wife. prior to 1994, he says he undertook these tasks. Then deals with the issues pertaining to the facts underlying limitation. And at paragraph 46 takes up the history. Paragraph 48 on page 163, Lord Justice, His Honour Judge Saffman deals with part of the cross-examination and the failure to consult the GP about problems with fingers. At paragraph 49, the first of the references to the difficulties with the oral evidence, where the judge recites that the claimant stated that his witness statement misdescribed the position as to giving up fishing. It wasn't clear as to why his statement suggested otherwise. Couldn't offer any explanation as to why he didn't take the opportunity to discuss his apparent problems with his hands with the GP. And then the judge continues about the dearth of references, the industrial disablement benefit application, in the claimant's favour, possibly in paragraph 52, the judge recites that in the application for industrial disablement benefit, the claimant had stated, "I find it difficult to thread hooks when I go fishing." But of course, the other side of that coin was that he was clearly giving an account of going fishing after he had said and revised his evidence that he'd given it up. In 67, there was an application for incapacity benefit. Asked what was wrong with him, he said back pain, no mention of VWF. His oral evidence that it was really my back that at times stopped me from doing manual tasks. When the claimant saw Professor Kester that year, he didn't mention his condition precluded or interfered with any activity other than fishing and motorcycling. Paragraph 54, page 164. So the judge then continues to recite inconsistencies as identified in the cross-examination and with the documentation. Paragraph 57, page 165, right to mention the questionnaire stated he was unable to pick up and carry 5.5 pound bag of potatoes with one hand, but could with the other. Paragraph 60, page 165. I've already referred to Mr. Tennant's report. He saw the claimant in February 2013 and took a history from him. He stated in his report at paragraph 2 that the claimant told him that his only medical history was of a painful back since 1994, which does not generally bother him. That is certainly not the picture painted by the documents to which I've already referred. The claimant could offer no explanation from the witness box to account for this discrepancy, save that he couldn't remember saying it. It's the claimant's evidence that his VWF, paragraph 61, page 165, precludes him from gardening and has done so since about 1994. Then describes the garden. And in November 2003, the claimant attended the doctor because he had backache. The GP note records that it had worsened since collecting leaves the other day. In 2005, he attended the GP again because he'd hurt his foot. The GP recorded that the claimant had been doing a lot of gardening with poorly supported shoes. Top of page 166. The claimant says that the GP had got it wrong. The claimant had just gone out into the garden in slippers to oversee some work in the garden being undertaken by his sons, and he had tripped. He does not know why the GP appears to have misunderstood the cause of his injury. What we're getting in this judgment, as you get in any judgment, is the judge bringing together high points, islands in the ocean of the evidence which he has heard, which particularly influence the conclusion which he is going to draw. He then goes on to the Facebook page and recounts that the claimant went on fishing holidays in 2011, 12, 13 and 14. Says that it arises out of the defendant's Facebook entrance, and discusses why the judge is concerned by that. Paragraph 67, Mr. Quinney draws attention to the fact the claimant appears to have no difficulty in holding these large fishes, but is telling the benefits agency cannot lift a 5.5 pound bag of potatoes. Holding the fish for a photograph, the claimant said, was the work of a few seconds and certainly insufficient time to affect his fingers. He then recites Dean Perry's evidence. And at page 70, on page 167, explains the judge's view, second half of the paragraph, neither explanation explains why even when Dean was on Facebook he wasn't a member of this swap shop, and why he felt he couldn't access his own Facebook page even when at his father's home. This was because the son was saying he was using his father's Facebook page for membership of a fishing tackle swap organization. Of course, it was the case that it was the father's Facebook page. He was swapping the fishing tackle. The judge then goes on to paragraph 171 on page 167. I heard Mrs. Helen Perry and Scott Perry. Their evidence was directed at the factual matrix. Both they and indeed Dean were clear that the claimant had performed all the service tasks before 1994, but could not do subsequently, and that those tasks were then undertaken by one or more of these members of his family. So he recited the evidence. He sets out the law and the standard of proof. Mr. Quinney doesn't shrink from the contention that in this case, the claimant is promoting a dishonest claim. He attacks the credibility of the claimant as to the level of his disability. In his opening, Mr. Greenbaum noted that dishonesty was not pleaded and referred me to Hussein and Amin in support of his contention that the pleadings were consequently defective.
So I wonder if I may take you back a paragraph,
yes,
which slightly concerns me. When he discusses in 73 the evidence of the family, he discounts it because the evidence wasn't clear whether their involvement in the tasks was because of vibration white finger or something else, his back.
That was one of the sons, yes.
That's one of the sons, yes. But later on, he says, if I had to make a finding on comorbidity, on whether it was his back or it was a comorbidity, he says, I just go for a comorbidity. So is 73 an adequate reason for rejecting one of the son's evidence?
Well, your Lordship will see the evidence. It's very short.
I've seen it. Yes.
It's very vague. The judge recites it loyally and
yes,
at the end forms an overall view.
Yeah, well, I agree there's a question of an overall view. Yes. But the fact that he wasn't clear whether it was his back or not would have to be weighed in the light of what his eventual finding was about the potency of the back injury.
Right.
Yes. Thank you.
Paragraph 75, his point, however, and I clarified with him, was not to assert the defendant in this case could not make that assertion. No doubt because it doesn't come as a surprise, but that if it did, then the defendant must establish it. He cited, and I don't criticize him for it, the time-honoured mantra, the more serious the allegation, the more cogent the evidence to support it. So that's how the dishonesty issue was left before the judge. He then goes on to deal with the familiar case of Rule B, and I need not take you to that, and then goes on to deal with the law of limitation, and I need not deal with that. Turning on to page 170 at paragraph 84, basic principle of the law of negligence, that subject to specific and fairly limited exceptions which are not suggested to apply here, that in a claim for negligence, one can only recover for the loss sustained. The general principle is that the purpose of damages is to compensate for loss suffered by the wronged party, not to punish a tortfeasor or provide the wronged party with a windfall.
I must warn you, Mr. Pools,
I'm
you've
coming
got
up to
less
time,
than 3 minutes left.
I'm very conscious of that. So we come to causation at paragraph 88. The key issue, it is at paragraph 88 where he sets out the test of causation, and he sets it out correctly. And the correctness is re-emphasised at paragraph 91, where he identifies the separate issue of loss. The findings as to causation start at paragraph 103. He then deals with an argument a learned friend made as to causation, as to loss, which he rejects. And he then deals with the issue of causation starting at paragraph 114. I can deal with this very briefly because most of it I've dealt with in dealing with the Court of Appeal. On page 175, he deals firstly by reminding himself about Professor Kester and Mr. Tennant and the diagnosis. He emphasises the importance of that evidence at paragraph 118, but the significance of it is at the end of paragraph 118, at the top of page 176, where the right question is identified by both counsel. We then go to 119, where he rightly identifies it as a matter of credibility. And he sets out the conclusion at 120, very briefly. I'm bound to say that the claimant's evidence was far from convincing and I'm not satisfied by it. I don't ignore Re-B. However, the fact of the matter is that much of the claimant's evidence was at variance with much of the written and extraneous evidence, and his explanations for this were not impressive. Neither do I ignore that the claimant clearly did suffer from VWF to a high degree. Again, the judge has the medical evidence well in mind. I have to be satisfied that in actual fact he couldn't perform unaided the tasks which he did carry out unaided before the onset. He then goes on to deal with the evidence, the inconsistencies which he finds. I don't propose to repeat them now. He's concerned about the medical evidence on page 178 at page 132. He deals with the evidence of the family at paragraph 133 and works his way through. In the final paragraph, he reminds himself in paragraph 136, final paragraph of this passage, 136 at 179, the man is, when all is said and done, unsophisticated and uneducated. I have in mind the points recorded at paragraph 18. I accept them. That's to say the points as to the cohort. However, the inconsistencies which lead me to reject the claimant's evidence are not simply confined to errors in dates.
You are now out of time.
My lady, and I have finished with that judgment. As we've seen, the law is not in issue between us. In our submission, we've demonstrated, firstly, that the Court of Appeal fundamentally failed to distinguish between Category 2 and Category 3 issues under Allied Maples, and consistent with the entitlement of an appellate court to interfere with the factual findings, doesn't come close to any of the established bases for substituting its view for that of Judge Safman. Yes.
No, thank you very much, Mr. Pools. Mr. Quine?
May it please my lady and my lords, it is never comfortable to start one's submissions with acknowledgement of two errors. My lady, my lords, these were set out in our written case at page 94 of the core bundle in paragraph 25. And that explains how it was that in paragraph 19 of her judgment, Lady Justice Gloucester indicated that it was accepted that it was accepted by the appellant, that is the claimant in the case, that it was necessary for success for him to be able to establish that he could honestly have brought a claim and satisfied the factual matrix. My learned friend who did the trial did not make that concession at trial. It was only when formulating the skeleton argument in support of the application for permission to appeal to the Court of Appeal that unfortunately that concession found its way into that skeleton argument, and permission was granted to pursue the appeal.
Mr. Watt-Pringle, of course, we've looked at the way in which the concession was made in the skeleton argument, which is, of course, tab 47 in Core Bundle 2, paragraph 10. But insofar as you say that concession was not made before the trial judge, we mustn't forget that paragraph 10, it's page 907, says, for the avoidance of doubt, it was common ground that, in order to succeed, Mr. Perry had to prove that if properly advised, he'd have made a genuine claim.
Well, that was part of the underlying error that was made in the skeleton argument, my lord.
I see.
Yes, because we have checked the transcripts, including the transcripts of the submissions that were made at trial, and that concession was not made. And unfortunately, when the replacement skeleton argument was lodged at the Court of Appeal, which under the rules is only permitted to change the pagination, not to add submissions, my name, unbeknownst to me, was added, though I'd had no input at all in it. I made the error at the hearing before the Court of Appeal of not disavowing those paragraphs, rather of making positive submissions, which in the event found favour with the Court of Appeal and have been rehearsed in the written case in this court as to why the stance taken by the trial judge, His Honour Judge Safman, in respect of causation was wrong in law. My lords, there are other passages in the judgment of Judge Safman which wrongly record a concession as having been made. And one of those passages is set out in our written case at page 82. And it is taken from paragraph 118 of Judge Safman's judgment.
It's which paragraph of your
Paragraph of your case?
It's paragraph 6 of our case at page 82.
Thank you.
As Mr. Quiney emphasised, and as indeed Mr. Greenbaum agreed, the claimant must establish that he would have advanced these claims and that, as a fact, he could not carry out the tasks unassisted and had done so before the onset of the EWF. Now, those italicized words, and that as a fact, were not agreed by Mr. Greenbaum, and that point is made in paragraph 7A on page 83 of the case. It should be noted that that point was taken in the reasons for refusing permission to appeal, which is in this bundle at pages 35 and 36. And it's at paragraph 8 at the bottom of page 35.
I'm sorry, we're going to... Where are we going?
It's in the
notice of objection
for refusing permission to appeal, and it's the bottom of page 35, my lord. And it's where Judge Safman's error is referred to for the first time. Contrary to any such concession, the skeleton argument set out the submissions advanced above concerning the impropriety of conducting a trial within a trial, and referred to four first instance decisions in claims against Raleys where this had been recognized. So, my lady, my lords, with respect, there were two errors made, and with respect...
With respect to whom?
Well, my lady, what I want to say is that the point made by my Lord Wilson was correct, that a concession which is made in an application for permission to appeal to the Court of Appeal and is not then pursued in the Court of Appeal and is not the basis of the decision of the Court of Appeal should not be one which takes the law in a different direction from that which is the proper direction.
Well, we obviously have to try and decide what the law is.
Yes, yes.
And we'll try not to hold it against you.
I'm grateful.
Or the Court of Appeal, that concession was made. We will try our best.
If your ladyship would bear with me just a minute. My friend could perhaps deal with this point himself.
I haven't been responsible for this. It's right that I can deal with it rather than it's not right to say that I didn't make the concession to trial. Because in my oral opening, which you do not have, I said that if the claimant is not making a determined claim. Oh, I'm sorry.
Page?
But Your Lordship, you don't have
This is the oral
This
submission.
is your oral opening at the trial.
We don't.
Yes, which you don't have, but it is
What did you
right
say?
that you should. What I said was this: if the claimant is not making a dishonest claim before Your Honour, then it's my submission that he must win, because he cannot fail to establish causation. It has been made by the claimant's side very clear from the very beginning, and certainly in front of Judge Hawksworth in April 2011, that was the generic case management conference that my friend Mr. Pools referred to earlier, when the point really first arose, that a claimant who puts forward a dishonest claim now, or whose claim for services would have been dishonest if made, cannot succeed in an action against Raleys now because such a claim would be contrary to public policy. That was a decision that was taken not just by me, but by my team in 2011. Was it for reasons I need not go into, but that was maintained, and at the trial in March 2015, I maintained it. And Mr. Watt Pringle did not relish having been landed with that concession, which, on the basis which he will expound, but based on Hanif largely, and other cases, cannot be correct. So that is the correction which and confession, which I needed to make.
Thank you very much, Mr. Greenbaum. Thank you. I'm imagining that Mr. Quiney will agree that that's what happened.
My lady, I do. And it's also in the skeleton argument as well, which is in your bundle if you need it.
I'm grateful, my lady. If I may then proceed to deal with the substance of this appeal. In our submission, the Court of Appeal was right to reverse the decision of Judge Safman for at least 4 good reasons. The first was that he misdirected himself on the issue of causation. He made the fundamental error of holding that the causation issue required Mr. Perry to prove on the balance of probabilities, first, that he would have made the claim if properly advised. That was correct. But the 2 errors were that he satisfied the factual matrix of a services claim, and secondly, that he could honestly have made such a claim.
Well, it's a bit tough to say that the trial judge misdirected himself in the light of what we've just heard. I know that's the usual way in which counsel put it, but I think that's a rather unfair way to put it.
Well, I take your ladyship's point, but with respect, what we are saying is that it is wrong to say that on the balance of probabilities, as part of the causation issue, the claimant must prove that he satisfied the factual matrix.
That, I wasn't challenging on that. It was the second part.
And as a matter of law too, my lady, with respect, it is an error to say that the claimant bears an onus of proving that such a claim would have been honest. The second error that the judge made in our submission was contrary to long-established precedent of some 60 years. He wrongly carried out a trial within a trial of the underlying services claim. And that was particularly inappropriate in this case, where the VWF compensation scheme was a far less exacting and adversarial process than an ordinary civil claim for personal injuries.
I'm going to ask a question that I think I put to Mr. Pools. Those who've been engaged in this litigation for some time will no doubt have some recollection of why His Honour Judge Hawksworth gave the generic direction that he did for the re-examination of these claimants. That seems to me to be somewhat material to this question of what everybody thought they were doing in these cases against the solicitors.
Indeed, my lady. I was not involved at that stage.
I know you weren't.
And Mr. Greenbaum was, and I wondered whether he might be able to assist on that.
Well, if he'd like to wait until after the short adjournment to think it through and possibly agree with Mr. Quiney, who may also have some, as to how these things came about in front of His Honour Judge Hawksworth, it would certainly help me.
Well, we hope we will be able to assist.
Yes. Meanwhile, carry on. Point 3.
Yes. The first 2 points really go to ground 1 of the appeal.
Yes. Yeah.
And the next 2 go to ground 2. We say that he misdirected himself on the requirements laid down
in the VWF compensation scheme for a services award, in that he found that the claimant had failed to discharge an onus, that he could no longer do any gardening at all, rather than simply no longer do it without assistance, which is the real requirement under the scheme. And though the fact is that though dishonesty or the public interest, which may arise, for instance, where a defence of extirpe causa is pleaded, or a defence of fraud is pleaded, had not been properly raised in the trial, it was allowed to insinuate itself into his judgment as a shadowy defence. And just before my learned friend finished his submissions, he drew attention to that particular paragraph, and I shall take the court to it, in Judge Safman's judgment, where he said Mr. Quiney does not shrink from saying that it is a dishonest claim. Lady, I wonder whether that is an appropriate moment.
Sounds exactly right, like the right moment. Yes. We'll look forward to hearing from both of you at 2 o'clock.